Good morning, Ms. Clerk. Excuse me.
Good morning, Council. If we have participants who will be directly participating in the McCoy versus Bay Cities matter, please raise your hand right now. It's the raise hand feature is at the bottom of your screen. I guess we don't. Good morning, attendees. The first case called this morning will be McCoy versus Bay Cities Produce. If you are participating in that hearing, please raise your hand now. The raise hand feature is at the bottom of your screen.
Good morning.
Good morning.
I'm Martin Horowitz on behalf of the plaintiff.
Thank you. Are you unmuted? You're still, okay, I think you're unmuted now.
Okay, thanks. Bonnie Glatzer on behalf of the defendant.
Thank you. And Jesse, if you could unmute and start your video. Do we have someone named Jesse, counsel in this case?
Not that I'm aware of. We will be joined by Joseph Peretz.
Okay, I'm going to put him back into the attendees. And as a reminder to everyone, as an attendee, please raise your hand only if you are participating in the case that I'm calling.
Yeah. Mhm.
Counsel, FYI, you see my name, Bell Ball. I'm the court reporter today.
Good morning, Your Honor.
Morning.
Good morning, Your Honor.
Good morning.
Morning, Your Honor.
Morning.
I will make a few announcements before we get started. When you are in the virtual well, please mute your audio when you are not speaking. It's better for the court reporter to transcribe the hearing that way. And also to everyone, any other recording of this proceeding, either by video, audio, including screenshots or other copying of the hearing, is strictly prohibited by the court. So, Your Honor, with that in mind, I will start the proceeding.
All right.
This meeting is being recorded.
Calling civil action 19-6989, McCoy versus Bay Cities Produce. Counsel, please state your appearances for the record, beginning with plaintiff.
Good morning, Your Honor. Martin Horowitz on behalf of the plaintiff.
All right. Good morning, Mr. Horowitz.
Good morning, Your Honor. Bonnie Glatzer from Nixon Peabody on behalf of defendants.
All right. Good morning, Ms. Glatzer. What is the current status of Mr. McCoy? He is now still employed at this moment, or what's happening?
He
Correct.
is,
He's employed, Your Honor, but he is on a leave of absence because he does not want to come in during COVID.
All right. And what is the amount of wages so far, at least in controversy in this case? What's the size of this case, wage-wise?
that's a very good question, Your Honor. And unfortunately, I don't have that calculated right now. There's a great deal of dispute about the precise measure of the wages because of the issue relating to the termination of his benefits on or about September 28 of 2017 and the consequences of that. He had been out of work for a substantial period of time, but there'll be a dispute as to whether his ability to return to work was in part a consequence of the employer's cancellation of his insurance, or whether it was not a result of that alleged liability.
In other words, just caused by his medical condition, independent of
Correct.
and part of the argument is that without the benefits, he was not able to get the kind of care or treatment or therapy or something.
Yeah, we intend to prove that he had a treatment plan in order at the time that they secretly canceled his health insurance, which became completely derailed at that time. Now, the consequences of the termination of his health plan at that time is going to be in dispute, but it's our view that it derailed him from getting the treatment, thereby prevented him from being capable of returning to work for some substantial period of time.
What was his wage roughly, either hourly, monthly, or whatever? Just curious.
No,
I
that
think
just,
it was about $22 an hour
I think counsel is correct.
in that
Your Honor.
range.
Your Honor, I
Yeah.
have additional counsel who is waving his hand.
Oh,
Shall I promote him?
who is that?
Joseph Perez.
Yeah, he's counsel, right?
He is, Your Honor.
All right. All right. Good morning, Mr. Perez.
Good morning, Your Honor. I've been listening to all of you and I've been waiting patiently, but I've been through the entire proceeding and
All right. Good. Good. Is there something you want to add that you'd like?
No, not at all. I just want to be made aware of. That's it.
Okay.
That's all.
All right. Well, you're in the well now, so welcome.
Thank you, Your Honor.
So I could see there's going to be some question about causation and damages and this sort of thing. All the more reason why I think I'd like to get you all into an ADR process, because these are the kind of things that can be sorted out, and at least you might get a good exchange on this, and maybe with the help of a neutral. It sounds like, though, we've got 3 different alternatives that not everybody's agreeable to. There's private mediation, there's magistrate judge settlement conference, and there's early neutral evaluation, which is the court adjunctive process. So let me hear your thoughts about what would be the most productive, effective way of moving forward. It sounds like the defendant thinks there ought to be some evaluative component to this process. Is that what I gather? Ms. Glover?
Correct, Your Honor. And I don't think our client will be willing to pay anything for settlement unless someone looks at this case and explains why there's a reason to pay for settlement. I understand plaintiff says there's the dispute about medical insurance, but we sent all the COBRA forms and we have all the documentation of that. And we gave Mr. McCoy, in our judgment, everything he was entitled to under the law. So my client feels it didn't do anything wrong. Plus, as soon as his doctor said he could come back, we brought him back. No one could have foreseen the COVID issue. So I tell you, we're going to go to mediation and my client's not going to be willing to pay anything. But I discussed early neutral evaluation with them, and they felt if somebody looked at this case and explained that there was a reason to pay something, they would look at that differently.
All right. What's the plaintiff's view about early neutral evaluation? Now you hear what the potential barrier is in the defendant's position. What's your thought about this, the process of a neutral evaluator looking at your cases and giving you some hard views or frank views, both sides, to both sides. So have you used our E&E process before?
Your Honor, I've been to E&Es and I found them to be, I wouldn't say useless, but not so productive, because the mediation process is an E&E, but plus the addition of attempting to settle the case. And with all due respect, Your Honor, I don't need the defense or an E&E neutral to tell me what's the risks or what's the position of the other side. You know, we know that there's some disclosures made. We know the pleadings, we read the pleadings. They claim they send notices. We claim our client never received any COBRA notices. So it's what it is. And the few E&Es that I've did were just not productive. You sit there and somebody tells you, again, I'm not attempting to disparage anyone, but hey, these are the risks you're facing and these are the risks the other side is facing. And okay, well, I know that. And so it seems like an exercise that doesn't advance anything, in my opinion. So if we want to advance anything and attempt to resolve the dispute, we can go, I'm open. I mean, I think private mediation is better, not because the magistrate judge option is not better, but usually magistrate judges don't have much time. And this is a case that have 2 or 3 layers. You have the COBRA issue, you have the employment issue in the past, and you have the present issues involving his current employment. So it's a little bit complex for an employment case. And I don't think that within the 2 hours that usually the magistrate judges have, they're just busy people. I don't think it's going to be enough time to resolve everything, particularly when you hear from the defense now that their client doesn't want to put anything on the table, which is fine. So my position, hearing all that, is either they agree to mediation in good faith, obviously, or we just, we do discovery and we take the case to trial. I mean, there's always this option.
Well, counsel's indicated that an unwillingness to pay for private mediation. Is that right, Ms. Glaser?
My client just doesn't want to go straight to mediation, but early neutral evaluation, which I've done a lot of, can always be converted to a mediation. So usually what happens is the evaluator comes in, and if they take a position about the case that favors one side or the other side, it's educational for everyone. But then, if they've given you some new information or some reason to settle, then they turn it into a mediation.
Well, let me ask you this. Let me ask you this: what discovery, in order to wherever you go, it's important that the parties have enough discovery so they know, see what the other side's documents are, et cetera, et cetera. And I think that'll make for a more intelligent discussion. Tell me what pre-mediation / settlement conference / E&E discovery would you need? I call it phase 1 discovery. What
we just need the plaintiff's deposition.
All right. So
I think we've exchanged paper discovery, but we need the plaintiff's deposition.
All right. What about from the plaintiff's side? Do you need any depots or other documents?
We need at least 2 depositions. We need the president of the company, Steve Del Maso. We need the person who supposedly sent the termination of insurance letter and supposedly sent the COBRA letter, the then HR director, Mr. Nishioka, I believe his name is. That's the absolute minimum. And probably the Vince Del Maso, the son who was the vice president.
And why do you need the president and the vice president? This is for mediation purposes, not for trial.
Well, each of those 3 people are fact witnesses to the central disputes in this case. And I think that the issue of whether there was a termination, the issue of whether they sent notice, the issue of when they sent notice, the issue of whether the personnel file itself is bona fide. Each of those people have a different perspective on that. Certainly Steve Del Maso, the president of the company who we allege terminated him in December 2017, and Nishioka, who supposedly sent the notices, they're absolutely essential.
So that sounds like there's a major factual issue about, for instance, the COBRA notice being sent or not sent?
Correct.
And what do the documents show? Is there documentary proof?
There are 2 different personnel files that were given to us, one in January of 2018 directly from the company and then a second one in March. They differ in some respects. Those personnel files do contain a notice dated September 28, 2017, ostensibly giving notice that the health benefits will be terminated effective October 1. That was never received by my client. He'll testify to that. Now, even if they sent that notice, they had an obligation to give 15-day written notice prior to the cancellation of health insurance. So by the face of that document, they failed their statutory obligation, even if they sent it. So we need to go.
There's supposed to be an additional notice, additional 15-day notice?
There's supposed to be by statute a 15-day written notice to the employee that the employee can begin paying health insurance. And if not, the employer can then cancel. By the terms of the September 28 letter, even if they sent it, they cancel it 3 days later, effective October 1.
Oh, so it wasn't sufficient notice, you're saying?
Yes,
Wasn't
it's facially, pardon me?
Yeah, okay. I'm curious. We're not going to try this case now, but Ms. Glasser, what does your file show about this 15-day notice requirement?
Well, the file shows that when he went out on a leave of absence, he was told his benefits would be continued for 90 days. They were actually continued for longer than 90 days. They were continued for about 4 months, and then the notice of cancellation was sent. So that appears to be statutorily compliant because he had advance notice of the cancellation. Plus, the file shows a fully compliant COBRA notification, which he never responded to.
So your client's position is that he was told 90 days or 120 days in advance. That satisfies the 15-day notice period?
Yes, yes, he had ample advance notice.
Okay. Of course, we disagree.
Yeah, all right. Here's what we're going to do. I'm going to refer this to a magistrate judge. Ms. Bretz, my understanding and my experience is that magistrate judges will spend as much time as warranted. If it's 2 hours and it's obvious it's not going anywhere, yeah, I've been in that situation. I pull the plug as a magistrate judge. On the other hand, I know my colleagues often will stay with it for 6, 7, 8 hours, come back a second day. If there's progress, it depends on how much. And I think the advantage here of a magistrate judge, you are certain to get both elements. You're going to, like it or not, you're going to get an evaluation. And I hopefully all the your clients will recognize that you're going to get an evaluation from an experienced judge. And two, they're there to try to see if they can broker some kind of a deal. So I think all the elements will be satisfied. And what I'm going to do is to say to be held within 90 days if possible. Everybody's of course doing things by Zoom, but I'm understanding that they're having actually pretty good success because there's a chance for private caucus breakout rooms and everything else. So 90 days, and in the meantime, the defendant will be allowed to take plaintiff's deposition. I'm going to allow the plaintiff 2 depositions, and I want you to get whatever documents you need to be exchanged to get that done, because I want you to go in there fully equipped and not with any hands tied behind your back, because I really want you all to see if you can resolve this case. And then we'll come back in 120 days for a status conference. Angie?
December 10th, Your Honor.
December 10th.
At 10:30.
Okay. And I'm going to set a trial date. I understand that there's a bit of a difference here, but I'm going to, in order for this December 10th, let's see, how many other witnesses, if you don't settle this case, how many other witnesses might there be besides the 3 depots you're taking? There's the one more, the vice president. Is there anybody else post mediation that you'd have to take depot wise?
We definitely need to take the person who participated in the hiring process now. That may be a short deposition.
Okay.
And then we have the vice president, the son, who
Right.
was a recipient to many of these events.
Right.
And I can't think of anyone that we know of right now, in addition to those,
Okay.
But there
as
may
far as recipients.
Right.
there may be, I mean, we don't know the facts now, so there could be another couple of HR folks that we need to take, or prior manager, But I don't expect this case to have more than 5-6 depositions from our end.
All right. Well, discovery will be lifted as of once you complete your settlement conference, and if it doesn't resolve. I'm going to set this for July 26, 2021 trial, which will give you until January 21st to 2021 to complete non-expert discovery, and dispositive motions would be filed no later than March 11th. So you'll have, I think, plenty of time. Obviously, if the case does not settle, you'll have to make sure that you schedule your depositions over the next couple of months before the end of January. But I do want to give this a full effort to try to resolve before you launch to the final phase. I will get out a scheduling order that has all the dates, the trial, pre-trial, discovery cutoffs, expert disclosures, et cetera, et cetera. But I did want to give you a date and see if you have something to work with. But I'm hoping that you can have a productive session with the magistrate judge. And otherwise, I'll see you back in on December 10th.
Your Honor, a quick question, if I may.
Yeah.
Just a point of clarification. In terms of discovery before we go to the settlement conference, my understanding is that we are able to take 2 depositions and also serve any request for productions we want. Just want to clarify that.
Yeah, I want you to get the documents. I'd like you to have it focused. I don't want to necessarily see broad contention interrogatories backed up by RFAs and, focus. You can say that for post settlement. I'm trying to keep costs, rein in costs to a certain extent. That's why I want you to just focus and zero in on the critical documents, critical witnesses, so you can intelligently assess your risk.
And Your Honor, we've supplied all our documents. We did initial disclosures, and then they asked us for additional documents.
Yeah, and that might be, I'm not saying there isn't, but I'm just saying to the extent that I'm not going to preclude any written discovery. If it's already been done, that's great. But I'd like it focused. Whatever you do, whoever promulgates any further discovery requests written.
I didn't mean to accuse the defense that they're withholding anything. I just want to make sure that we can at least ask for things we think are relevant.
All right. So I wish you success with the magistrate judge. If not, we'll see you in December.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. Good luck. Thank you.
Bye, everybody.
Bye.
Bye.
All right, to the attendees, the next matter is the Penny Baker et al. Versus Kwan et al. Those participants who will be directly participating in the proceeding, please raise your hand right now. The raise hand feature is at the bottom of your screen.
Hello.
Hello.
Good morning.
Good morning.
All right. We're not seeing Mr. Is it Mr.
Rethorn.
Rethorn?
It seems Zoom is unable to detect a camera. I do have a camera. I'm not.
You might hit your lower left box. I don't know if you're on what kind of device you're on, but where it says stop video. If you hit the up arrow, it'll also let you select the camera. Sometimes it doesn't select.
Yeah, all right. Taking a look.
Your Honor, there is another counsel, Mr. Garth Ward, who is having some technologically difficulties this morning. I sent him an invitation, and that doesn't seem to be working. I believe he's tried the call-in numbers. The list of numbers for the meeting ID doesn't match up. So I'm not sure if he's going to be able to appear.
Well, Mr. Rodowicz, do we need, does Mr. Garth need to be,
Yeah.
well, he represents Davis Realty, I guess.
We are separate, but he's actually been emailing me. I can communicate with him, Your Honor, and he told me what he wants to say, so I can get responses with him right now. But he is having technical difficulties.
Okay. The other thing we've done is if he's on a cell phone, if you dial him up and put him on speaker, and just hold the cell near your microphone, he will be able to hear us through the audio, and we can hear him. I don't know if he's available by cell phone.
I'm asking him to, please.
Okay. Otherwise, we can, or you can just email back and forth with him. If
Right.
Text.
I believe he said he can hear. So. But he'll probably call my cell in a moment, Your Honor.
Okay.
As for my video, it seems like it will not be working. I can't get any video settings to pull up in Zoom right now, but I can call through a cell phone if video is essential.
It's not essential. I mean, this is a status conference. I think as long as you're here audibly, besides, that's the way we used to do these things.
Fair enough.
Not too long ago. So, all right. Well, why don't we proceed and see how far we get with this, and hopefully we'll have Mr. Ward available to at least comment if he needs to comment. So
I'll call the case, Your Honor.
all right.
Calling civil action 20-1668, Penny Baker et al. Versus Kwan et al. Counsel, please state your appearances for the record, beginning with plaintiff's counsel.
Hi, this is TJ Weethorn or Thomas Weethorn representing the plaintiffs.
All right. Thank you, Mr. Weethorn.
Ed Rodzowicz for defendant Robert Kwan as an individual and as the trustee for the Robert Kwan Real Estate Trust.
All right. Thank you, Mr. Rodzowicz. And we have Mr. Ward sort of participating via you, I guess, Mr. Rodzowicz. Is that right?
I think he's coming in right now, Your Honor. So, Garth, are you there?
Yeah, how you doing?
Oh, good. Can you hear us, Mr. Ward?
Yes, I can.
Good. All right. So we're all here.
Oh, I apologize. Yeah, I apologize for my technical difficulties.
That's okay. I know people are getting used to this. Once you're able to do it, it actually works generally pretty well. So let me ask the question about consent to magistrate judges. There's an indication that Davis had consented and defendant Kwan, but there hadn't been any information yet on the plaintiff. Mr. Weethorn, do you have any update on that?
Yes. So I spoke to my clients about the matter, and they were of the opinion that if it's a settlement magistrate or magistrate that's overseeing a settlement conference or what have you, like we discussed, that would be fine. But as for the trial itself, they did not want to do that.
Okay. All right. Well, that's certainly their prerogative. At some point, I am, as you could hear, I'm in the process of assigning trial dates. I do have to tell you that, and it maybe is obvious to you, given the pandemic situation, we have now been postponing trials, and we're going to have a tremendous backlog And I, whatever date I give out, there's going to be a footnote attached to that, or an asterisk saying, we're going to do the best we can. And obviously, one of the advantages of a magistrate judge is that their calendars are not going to be nearly as impacted as ours, because we have to give priority to criminal cases. We've got due process and Speedy Trial Act mandates. And so my suspicion is that the vast majority of trials you're going to be seeing in the district judges are going to be addressing the huge backlog of criminal cases for some time. And those of you who want to get this resolved one way or another by jury trial, you might think about the magistrate judge option. That we tell people that generally, but it's more true than ever now. But you might want to just discuss that with your client, and you can always change your mind. You can always opt. But given this new reality, I thought I'd be upfront with you about that.
All right, thank you very much. If we have some sort of ballpark, I could tell my clients, it would make it would probably facilitate that, so they could see the time difference and make a good informed decision on that. Do you have any sort of ballpark? I mean, we're probably going to be getting into next year. Do you have any idea based on?
Yeah, setting any trial in early 2021 is probably not realistic right now. I can almost guarantee you that, because we'll be lucky to just be having criminal trials by then. A lot depends on the course of the pandemic and the availability of vaccine and all sort of stuff. As you can see from the last case, I did set a July date, and dates around then, that's probably where I'm beginning to set these dates. But in all realistic probability, you might have to wait another 9 months, 12 months. Realistically, if my schedule's impacted and I can't get out the trial, whereas you could almost certainly be able to secure a trial date within that time frame. If we're having trials, magistrate judges' calendars are more flexible, and you probably could get to trial in, let's say, the mid-July. That's my best guess. So, the difference, I don't know, 6 months, 9 months, a year, getting to trial. Hopefully not longer than that. As an example, I've got a big gang case that's set for trial in the fall that is 99% chance of going. That will preempt my calendar for 3 to 4 months. I'm not going to hear anything else during that period. And I have other colleagues that are in the same boat. So yeah, it could be a year's difference.
All right, that sounds that's useful information to know. I will talk about this with my clients. And,
okay, great. Meanwhile, let's proceed. I do want to talk about ADR, because that's always my first priority. The first meeting, see if there's a way that we can resolve this matter. What are the and I want to know, what kind of discovery do you need? There's mention here about some depositions, so maybe I'd like to hear from each side, each party, how many depositions you think you need, what kind of discovery, in order just to prepare for a settlement conference or mediation.
So this is Ed Rodzowicz for defendant Robert Kwan. We discussed this last week amongst all counsel, and we believe, if I'm correct, that we could go to mediation with just the Rule 26 disclosures, and try mediation, or maybe I suggest early neutral evaluation.
All right. Are all the parties in agreement that the Rule 26 disclosures will be sufficient to at least get to an ADR process?
Yes, that's correct.
All right.
Yeah, one caveat, this is Garth Ward of Affidavits Realty. I have not seen plaintiff's Rule 26 disclosures yet. I know that there was some discussion last week during our meet and confer process that it was necessary to evaluate some of the actually bodily injury or emotional distress claims that are going to figure into the damages analysis. From my perspective, So I'd like to be able to generally take a look at those disclosures first, but we're amenable to an early evaluation.
All right, great.
Those disclosures.
All right, now hopefully you can work that out. I mean, if you need to do some exchange that it goes beyond the normal disclosures, I think you should do that so that you can have a meaningful ADR session. Sounds like what I'm hearing now is that what might be useful is an E&E, early neutral evaluation. Are the parties in agreement with that?
Yes, for defendant Kwan.
Okay.
Yes.
And yes for Davis Realty.
All right. Then why don't we let's do this as soon as possible. Since you've got the documents, I'd rather try to get you in there as quickly as possible. Angie, if we can say within 60 days, I don't know if hopefully they can do that.
Yes, Your Honor, I will.
And then let's set a status 90 days out. If the case did not resolve, we can talk about options at that point. So you could set a status 90 days out, Angie.
November 5th, Your Honor.
All right. Now, let me ask, I guess I have a question about the case. This is a claim of, I don't know if you want to call it inverse discrimination, but discrimination against, I don't know, non-traditional families or non-families. As I understand it, the group of tenants were comprised of two different couples, two different families. Is that right?
Yes, that's correct. They weren't married or anything like that. They were in romantic relationships with each other, but they would not consider themselves families. They would be a non-family entity.
But there are sort of two groups?
Yes, that's correct, yes.
But 6 people or 4 people? I didn't quite know.
Four.
Oh, all right. And the landlord, at least according to the allegations, wanted one family, right?
That's correct. That's correct. Only families, no roommates.
Okay. All right. And is there, just educate me for a second about the law. What does the housing law say about discrimination against non-families?
The law as it's written, of course, makes discrimination based on familial status unlawful. So familial status would be defined naturally, logically, as either belonging to a family or not belonging to a family. In some cases, landlords will obviously discriminate against people who have children or the like, because it can increase the likelihood of property damage. But also, something that we're seeing here in the Bay Area is that a lot of younger people are having trouble accessing housing, even when they meet the financial requirements or the credit requirements of a particular landlord, and can afford rent, but choose to live together and find access to housing to be almost impossible. And many landlords will say, no, we don't rent to anyone that's not a family. We don't want to deal with it. And you simply just have to be a family to rent here. And it's our reading that according to the law and the way the law is written and the intent of the law is that familial status is a protected status. This was a discrimination that was made based on familial status. And in that case, we found that the discrimination was harmful in itself and negatively impacts young people in our positions. And I think that it's in society's best interest to address this problem. And that's
I'm curious, are there cases on point interpreting the familial status term to apply? I mean, obviously it applies to the traditional kind of discrimination against families, and typically families with children. I mean, that's what historically has been a problem. Are there any cases saying it applies where a landlord wants kind of the inverse, only families and not non-families? Have there been Fair Housing Act cases addressing that?
We find that there are analogies to which a positive formulation in the law can be logically read or logically entails a negative reading or an inverse reading. But that this may be one of the first cases that addresses this particular issue.
Interesting. But let me ask from the defendants, what does your research show? What's your legal?
This is Ed Rogers for Mr. Kwan. Yeah, the only appellate cases I can find on familiar status have to do with discriminating against children or discriminating against unmarried couples, saying you're not married, I'm religious, I don't want to allow you to live there. Those are the cases I can find. However, the reading in opinions about classifications comments that it's not meant to be exclusive. So I think a judge could rule that this is a class to be protected. I just can't find a case on point, but so I haven't found a similar case.
Oh, that's interesting. I remember from law school, there's that case about not renting to, well, in those days it was hippies, people, unrelated individuals. There were laws. It's a classic equal protection case about not renting to people who are not related. And that was brought about, as I recall, as an association, right of association kind of an issue. Interesting from first year law school, but that's ancient law at this point. So, well, that's an interesting issue. I was also curious, the kind of anxiety that's asserted here. One of the things that struck me is that obviously these are financially well qualified people. That's the allegation here, that they could afford up to $10,000 a month in rent,
Yeah.
Which suggests $40,000 in monthly income. And yet there's a statement here that Mr. Pennypacker is fearful of being homeless. So that's kind of a long fall from tens of thousands of dollars a month to homelessness. I'm curious.
Yeah.
What's behind that?
Dr. Pennybaker is a professional. He's doing his residency right now, so he makes less money than a normal doctor would. Altogether, they meet the income requirements for the places that they were looking at, but it is extremely difficult to find housing for 4 people. And because the lease at their previous place was terminated, it was a month-to-month lease, they had to find housing incredibly quickly. And all these places were, many of the places did not want to rent to roommates, and they would accept applications anyway. And so it was a very stressful situation, and they may not have found any sort of living situation at all by the time that they had to move out of their current place. And so he was looking at trailers to live in, and whatever else he could do to kind of prevent sort of a disastrous outcome. But because it is actually very difficult to find housing, even with those income requirements, it kind of highlights, this sort of issue, especially in their minds. And so they felt that this was a recurring issue with a lot of different landlords. And then they found a landlord that was very open about it and just said, no, we're not even going to let you look at the place. We're not going to let you apply to the place. And they felt, that was wrong. And there's a legal argument to support their case. And I think that that's in the interest of a lot of young professionals who want to get established in the city, want to contribute to society and help. And
are they renting now?
They are, yes. Yes, they are.
All right. So this is an issue of sort of retrospective damages then, largely.
Yes, that's correct, in the past.
Okay. All right. Well, let's set this up for a settlement conference. And we could set a trial date now, but at this point, I think it makes more sense maybe for you to have another conversation with your client, Mr. Wheathorn, to make sure that which path they want to take. If they want to consent, then we would do the trial scheduling. A magistrate judge would do the trial scheduling and would probably get you a date certain, a lot more than I could, as certain as one could be given the pandemic. I mean, nobody knows for sure, but I think it is a fair guess that given the backlog we're going to have, there's going to be a very substantial difference in terms of getting together and, frankly, the certainty of getting to trial. I will warn both of you, all of you, that probably what it's going to look like when we do get into a trial mode. Because of the way scheduling works, you may have to end up trailing like you do in state court, where you got to be ready to go. And we're going to go, we may be due back to back to back. And because we may only have 1 or 2 courtrooms available. And so we have to kind of schedule them very tightly. So there's going to be some inconvenience, at least with the district judges, in terms of, having to trail. And I know that's not fun, because if you've got witnesses and experts and you've got to set aside a longer block of time because you may be called on a day's notice to start trial. But I just wanted to forewarn you, we may look like that, hopefully not, because normally in the past we give you a trial date and it's clear and you get ready to go. But right now, given things, we're not sure exactly what the picture will look like. So why don't we get together at the next status conference on November 5th, right, Angie? That's what you gave us.
Yep.
And then if you consent before then we can arrange to have that done, and that'll resolve the matter at least before this court. And if not, if your clients decide they want to roll the dice and stay with the district judge, then we'll at that point try to set a trial date.
Your Honor, this is Ed Rodzowicz, and when we had this all sounds good. When the attorneys essentially agreed to this in our pre-case management conference meeting, but that meeting revealed that the plaintiffs have a videotape of the representative from Davis Realty. That's very key to the case, and the plaintiff has promised to turn it over. And the meeting also revealed that there are actual medical records, not just an anxiety claim, but medical records. So those are the 2 items that we really need before an early settlement conference can work. And we were promised them, we haven't received them yet. So that's to me is the only issue I see coming up if there's going to be any reluctance to produce those 2 items.
All right, Mr. Bithorn, any issue about producing those?
No, at all. Not at all. I'm waiting to prepare my disclosure form. One of my clients thinks they may have a screenshot of the Craigslist ad, the original Craigslist ad, but it might be on an old hard drive. So I've been waiting to get a final word on that before submitting my disclosure form.
All right. Well, if you could do that as quickly as possible so that the parties will be prepared. Not sure how long it's taking our ADR unit to schedule any of these days. In some ways, it might be easier given it's done by video for the most part. So, but I'm going to ask them to do within the next 60 days.
Yeah, absolutely.
All right.
Absolutely.
Well, I wish you success through that process. And if your client, if you could inform the court either way about their views regarding consent or not to magistrate judge, I'd appreciate it, Mr. Bithorn.
Absolutely. Yes, sir.
Great. All right, everyone. Good luck.
Thank you.
Thank you, Your Honor. Appreciate it.
Thank you.
Court is in recess until the 10:30 calendar.
Thank you.
Okay. I'm just going to go offline.
All
I'll
righty.
stay in the meeting, but mute myself.
Yeah, I'm going to get everyone gathered in for 10:30.
Okay.
If we have any participants here that will be participating in the Monteville Sloan matter, please raise your hand right now.